Hi all, today we're going to have a little chat about our laws and our systems that enforce and uphold these laws. So with me today, I am honored to have a person I call a friend, Richie, joining us, and he's with his son as well. So we have two people joining us to discuss this really great topic.
Hey.
So let's start with you sharing your name, a little bit of what you've done professionally, history-wise,
Okay.
and yeah.
I'm an attorney at law called to the bar in both Grenada and Trinidad and Tobago. I also used to do more, strictly speaking, human rights advocacy and activism work through an organization that I had, but now my activism is more exercised in the courtroom legally as an attorney at law. I have always had a very specific interest in human rights law, and that interest spurred me to do a master's degree in exactly that area, human rights. And so I recently started my own practice last year, and I've been trying to carve out a space to see whether I can just essentially do that. So I'm currently working on a number of human rights related cases, and that's the area in which I'm most passionate about.
Okay, very good. And actually, I would have met you when you were at K-Phil doing law years ago. And
Exactly.
And we also served on a board of a regional organization, Eastern Caribbean Regional Organization, which is UK. Together. So yeah. I remember you mentioning just now organization you were with, and that was Groundation Grenada, if I'm correct. That you
yeah.
Yes. So let's start. So what is a constitution, and what is our history, the history behind us as a Caribbean English-speaking set of nations? The story behind our constitution in this region.
All right, so the story behind our various constitutions, because they have had slightly different histories.
Mm-hmm.
The region I'm from, which is Eastern Caribbean, more or less would have had a sort of shared history. But of course, people may know that we were once, all of us in the Caribbean, all colonies of the United Kingdom. In fact, some of us, like the British Virgin Islands, still have not really fully politically separated, in that they are what some might call British overseas territories. And independence for us has been a long fight. There's been a lot of agitation, a lot of advocacy, and over the years, during the colonial period, there would have been an initial unwillingness per se to just completely give the colonies independence. So various arrangements were made whereby, for instance, there was a West Indian constitution that was sort of a precursor to the constitutions that we now have, which by and large are independence constitutions, which came about because upon our independence, the Mother England, as they would have called it back in the day, the colonizer would have given us what most countries still retain as their independence constitutions, upon our independence as a parting gift. So that's sort of how we ended up with it, which is somewhat strange because the United Kingdom itself does not actually have a written constitution. There's a loose constitution of sorts drawn from various documents, including the Magna Carta, including their legislated Bill of Rights and that sort of thing. But they actually do not have constitutions in a way that they have given us constitutions. Yeah, that's what you have to say about that.
You agree, right?
Yeah. So yeah, that's more or less the history of our constitutions, to establish a document that outlined the principles of governance for the newly independent states that were being formed or that were being established.
Yeah. Touch on like, what is holding someone at the crown's pleasure mean?
What's up? You hungry?
He's tired of sitting and looking at me now. Like Uncle Renee is boring me now. Move on. Yeah.
Right. The term at the crown's pleasure means literally that. So that a particular action is being done or a particular restraint is being effected at the sole and complete discretion of the crown. which in our current context means the Queen of the United Kingdom, who is still our head of state in title under the constitutional arrangements that most of the former colonies operates under. So it means, for instance, that there are no established regulatory oversights by statutory bodies or even by parliament in some contexts. It literally means that something can happen or not happen simply because the Queen or someone designated by her decides that it will not or it will. You know, so it's literally at her discretion or the discretion of her designees.
Yeah, and the reason I asked that too, because we've seen in a number of our islands this conversation starting with persons being held for, you know, long periods without ever being maybe going to trial, or they may have had a charge, but after that they're sitting in prisons for like 5 years, 10 years.
Right. So those are actually two somewhat separate issues in that we spoke earlier about the fact that the United Kingdom does not itself have a written constitution. But we as former colonies do have a written constitution, and that actually has important implications for our justice and legal system and just our politics generally. So the major distinction in concept or principle is that the United Kingdom is what you call a parliamentary supremacy. It means that, you know, of course, the crown still exists as an institution with certain powers, including veto powers and so. But outside of those contexts, it means that the parliament of the United Kingdom is supreme, that the courts do not have any power to be a check and a balance on parliament, you know, generally speaking. So in other words, they have absolute freedom to kind of determine what laws are passed, what they want to do or what they want to not do. But one of the implications of us actually having written constitutions, and not just written constitutions, but constitutions drafted in the way that we are, is that we are constitutional supremacy. So our constitution, as opposed to our parliament, is supreme. It means for us that whatever laws are passed or whatever action is taken by the government, it must be in accordance with constitutional provisions. And our constitutions actually say so. They all have clauses which more or less say that this constitution is supreme, and any law passed or anything done which contravenes provisions of this constitution is null and void to the extent of the inconsistency. So to draw that back precisely to the question that you are asking, one of the rights enumerated in the various constitutions is the right to, I think my son is falling asleep. Let me just putting on my shoulder. But one of the rights is the right to a fair hearing within a reasonable time. That is actually how the right is called. The right to a fair hearing within a reasonable time. It means that if someone is charged, then not only must their hearing be fair, but it must also be conducted and concluded within a reasonable period of time. Because of course, the issues would arise concerning the memory of victims, the ability of the person who's accused to gather evidence, to have access to people, to remember themselves, you know, what happened. And it just also is a very stressful process. This thing is hanging over your head. You know, it might involve the potential for incarceration. So it would be unfair to anyone to just kind of live for a very protracted period with that.
You're muted again.
Numerous cases have actually been done, specifically involving persons who are being held pending trial for very long times. And our courts have actually found that holding persons for these protracted periods of time is unconstitutional. It is a breach of one's right to a fair hearing within a reasonable time.
Yeah.
And one of the major cases, which I believe went all the way to the Privy Council, was the case of Pratt and Morgan, which concerned specifically death row inmates. And one of the principles coming out of that case is that if you have somebody on death row for more than 5 years, then essentially you can't execute them, because that's a special form of torture in and of itself. have to just live with the constant threat of being killed without kind of any certainty as to when it would happen for such a protracted period of time. But even outside of those contexts, our courts have made it clear that while they take into account local circumstances and the availability of resources, so for instance, the Eastern Caribbean is not well resourced in terms of our courts, as the United Kingdom might be, there is still a duty owed to people, such that if the circumstances cannot justify the length of time that a person has been held without trial, then oftentimes the courts order the governments to effect remedies, whether it means damages or whether it means striking the criminal case against them out. But there are in fact remedies for that, and it's not just that people can be held at the pleasure of the crown, you know, okay, because we have a constitution which makes all government institutions accountable.
Okay, I might come back to that in a little bit, but yeah, what I'm going to do is switch up a little bit and ask, are legal and judicial and police systems, are these different systems working together? And also, do these systems in our region, are they in need of reform?
All right, which systems? Judicial and what?
Judicial and policing systems.
Judicial and policing systems. Well, yes, they are in fact different systems, necessarily so. Mm-hmm. One of the values of our written constitution is that beyond the exact provisions that they contain, so for instance, the various constitutions all contain provisions which say some version of the fact that everyone has the right to freedom of expression or association, let's call it that. But our courts, because it falls to our courts to be the guardians of the Constitution. You know, when we say that the Constitution is supreme and all government arms are held accountable to that standard, the courts are the ones to whom that duty falls. So in exercising that duty over the years, the court has said that not only will we look at exactly what the Constitution says, but we will also look at how it is set out to determine quote-unquote constitutional principles that we can derive that we will still hold state organs accountable to, even if they're not specified. And one of those is a separation of powers. So most people might know that we have three arms of government: the parliament or the legislative, which is responsible for making laws. That's who we vote for come in independence time. There's the executive, which primarily is cabinet, but also extends to each and every arm of government that more or less executes the government mandate, including the police. So the police, strictly speaking, falls under the executive arm of the government. And then there's the judiciary, the judges, who, as I indicated, are the persons kind of holding the guard to make sure everybody abides by the Constitution. And what our courts have held is that because in the Constitution itself, the Constitution treats with these various aspects of government in different sections, then they have derived from that constitutional arrangement the principle of separation of powers, of keeping the various arms of government separate so that each can be a check and a balance on the other. So the police service is absolutely and importantly separated from the judicial system, you know, because otherwise the judicial system wouldn't be able to hold the police, let's say, accountable for things that they do which might be unconstitutional. So they are in fact separate. They separately are administered and administrated. They have separate functions, and yeah, they more or less separate in every single way. Mm-hmm. As regards to the second question of whether or not there needs to be reform, yes, absolutely there needs to be reform, but probably in all of our emanations of government, not only in police, not only in the judiciary, but every single aspect. I think we as post-colonial societies are still very much burdened by a lot of colonial baggage that we hold on to. So there is still a lot of internalized, racism, Caribbean-based racism that expresses itself in policing in various jurisdictions that I certainly would like to see reform. So for instance, there was a recent event which occurred in Grenada. No conviction has happened, so I will just speak about it as an allegation. It is alleged that there was a white family who essentially ganged up on this black man and beat him severely. The black man and his wife went on news after to relate what happened, but he had been driving in an area Grenada that is a sort of gate community that is considered upper class. And the white family was building a house there. He's a construction worker, so he was going to drop some of his workers, and the dog of the white family ran out into the road and got killed. And somehow the situation escalated into them beating this man badly, a man who had already been very ill and really couldn't defend himself. And what rankled me and other people in Grenada is the fact that the police's response when they got involved to the black man and his family was that, this wasn't a police matter, that they can pursue it civilly in the courts, but it wasn't a police matter, which is absolute nonsense, because there's clear evidence of assault and battery, or crimes, which the police would have been entitled to make arrests and to press charges against. But people protested, and I'm happy to say that the members of the white family involved are now actually charged. But those are incidences I would like to see not repeated in future. So there absolutely is an opportunity for overhaul and reflection and improvement.
Mm-hmm. Wow. I'm gonna, because that is a lot. You don't think that in the Caribbean should be happening still.
That what should be happening still?
That we have a judicial system that will favor certain races or classes.
Honestly speaking, in terms of the three different arms of government, the one that I have the most faith in is actually the judiciary. And I'm not making any suggestion that, for instance, that they are likely or that they do treat certain races or classes differently, because classism is also a big problem in the Caribbean. I mean, I have no evidence of that. There are no clear instances where I can point to that. Yeah. And in fact, there have been some powerful judgments coming out of the Caribbean where a sense of Caribbean identity and Caribbeanness is affirmed, which militates against some of those inherited colonial beliefs. So I think that as far as judges go on our judicial system, they're pretty independent and they're pretty progressive. So it's more the police force, which is an aspect of the executive, I would say, where the change needs to happen. Because yes, if the matter ends up in court, as much as the judge hearing this matter might be fairly progressive or neutral or fair, the fact is it can only end up in court as a criminal matter if the police lay charges, which they initially refused to do, but which they have now done in response to the public outcry.
And right, so when it was responding like, well, I should have really looked at, it was more the police bringing the charge, because that was what I was concerned about. So you had mentioned a few times, we hear this all the time, colonial laws, and you've touched on kind of what that meant previously. So I kind of want to just briefly understand what are colonial laws, and do you think that these are outdated laws in your opinion?
Oh, absolutely. I mean, not all of them. So let me just say, what I mean by colonial laws are laws that existed in some version even before we became independent, that essentially would have been imposed on us as then colonial subjects by the UK government or by the government employed by the UK to administer what was then a UK territory. Some of them are absolutely outdated. In fact, the UK has itself very long ago struck many of them off their own law books, but many of the former colonies, including Grenada, I know, for instance, there's a constitutional challenge in Barbados against buggery, still exists. So that is one example, the buggery laws. So in Grenada, it's expressed as unnatural connection, section 431. In Barbados, it has its own name. I believe it actually might be called buggery. It's called sodomy laws in other jurisdictions, but that is one of the colonial legacies. It is a reflection of Victorian values around sex and sexism, and it essentially criminalizes anal sex or certain forms of intimacy. that would have been considered unorthodox back in the day, intimacy between same-sex persons. Now, the UK has long ago, since the 60s itself, done away with them. But we, for some reason or the other, have chosen to sort of retain them. They are absolutely obsolete, outdated, anachronistic, whatever you want to call them, and I would love to see them go.
Yeah. The one in Barbados is in, I think, section 9 and 12 in our Sexual Offences Act, and it actually is about the act. It's not just for same-sex acts, it's about the act in general. I think they have something worded as well in section, I think it's 12, is sex or on for a natural purpose, which doesn't really have any definition, so it can be used in any way.
Right.